My name is Kent Holland. I am the founder and principal of Construction Risk LLC. Pleasure to present this webinar today on indemnification litigation. This is on behalf of AE ProNet. And these decisions that we're talking about come from around the country. The first case is one that addresses who is indemnified, and a court in New York said that the term of representative includes the owner's architect. So unfortunately, when the contractor agreed to indemnify the owner and the owner's agents and representatives, the court said, well, the architect was a representative. On the question of California law, if you're in California or California law applies to your contract, it's very important that if you agree to indemnify, you understand that that includes an automatic obligation to defend. And the only way to avoid that is to contractually put in the words, you shall not defend against professional liability claims. So we always do that in California. It's very important, as this case of Centex Homes from 2019 explains. There's a question about first-party claims and third-party claims. A third-party claim arises when some third party makes a claim against your client saying that it was damaged as a result of your services. And in that case, you're going to have to indemnify your client for those claims. You'll see in courts around the country that some courts say, yes, indemnity will include first-party claims, and others say, no, it's only for third-party. Well, let's look at a few of those and see what we can learn. In New York, the court says that indemnity can include a first-party claim. And the court explains that it's a familiar principle at common law that indemnity is only for third-party claims. But the court says, by contract language, you can make it broader than that. In this case, the court said that's what happened. It was WSA Group versus DKI Engineering. In Washington, D.C., there was somewhat ambiguous language in a contract, but yet the court said the indemnity only applied to third-party claims. It did not apply to first-party damages of the client. In Maryland, a court went the exact opposite way and said indemnity applied to first-party claims plus third-party claims. So here, the owner was able to recover damages from its engineer even though there was no claim ever made against that owner. New Hampshire, this was a really important decision to understand. In this case, the AE had a contract with its owner to do the design. The owner then had a contractor building that design. Contractor says, well, these designs are flawed. I need to have a change order to fix something. And the owner said, no, I'm not granting you a change order. So then the contractor filed suit against the owner. Now, this is a general contractor claim and a suit. The owner turned around and gave that claim to AE ProNet, saying, well, you have to indemnify us and defend us against this contractor claim. And the court held that indeed AECOM did have to do that, in spite of the language in the contract that said that AECOM would only have to do that to the extent arising from their negligence. AECOM argued those words protected it from that claim. And the court said, no, they don't. The words arising out of are interpreted so broadly that they don't mean that the loss has to be caused by your negligence, nor does it even require an action to be brought against you for negligence. You still have to indemnify them. So the only way to avoid that would be to say, we're only responsible for the extent caused by our negligence. But as soon as you put those words arising out of, you're in trouble. Florida will allow third-party claims under indemnity only. Georgia will allow first-party claims as well as third-party claims. What about an indemnity clause that violates a state anti-indemnity statute? What happens there? Will the court just throw out the whole clause? Well, not if you've put those words at the beginning of it that says, to the fullest extent permitted by law, this is what's going to be so. And in this case of Johnson versus Hamp Construction, those words were in the clause. Therefore, the court simply revised the clause and said, well, we're going to enforce it to the extent permitted by law, and therefore the indemnity still applies. A few indemnity drafting tips based on these cases. We think it's very important that you always clarify that you only are indemnifying for claims and damages that are from third-party tort claims. In addition, you'll find clauses that mix and match words together like claims, damages, causes of action, losses. That becomes very confusing as to what are you defending against, what are you indemnifying against. So we like to put all the types of words that involve a defense of a claim all together at the beginning of an article, and then say, to the extent there is any duty to defend, that we don't defend any professional liability claims. And then we'll say we will indemnify against the damages arising out of those third-party claims. If you've enjoyed this short video on the litigation, I hope you'll join me for another short video that addresses my specific recommendations for negotiating and modifying indemnity language to make the wording more insurable. Thank you. I hope you will visit the AEProNet website to see other short videos by other attorneys that deal with a number of important contract issues.